Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing K-1 visas from Thailand. This isn't specifically to Thailand, but I'm discussing it in this context because this is most of the cases we're dealing with right now. But the biometrics rule, a rule that was being promulgated by the prior administration, is now being withdrawn or rescinded. A recent announcement from Department of Homeland Security titled DHS withdraws proposed biometrics rule, quoting directly, the Department of Homeland Security has withdrawn a proposed rule that would have expanded department authorities and requirements for collecting biometrics by removing age restrictions, requiring submission of biometrics for every applicant, petitioner, sponsor, beneficiary, or other individual filing for or associated with any immigration or naturalization benefit or request unless DHS waives or exempts the biometrics requirement, codifying the authority to use DNA test results and authorizing the use of additional types of biometric modalities. So basically what they're doing here is the prior administration, in my opinion, placed really onerous requirements on folks, just as they even note, associated with any immigration or naturalization benefits. So yeah, biometrics, and we're talking about retinal scanning, fingerprints, facial recognition scanning. It may be required for certain immigrants into the United States to do this depending on what types of benefits they're seeking. For example, we see it a lot with respect to reentry permits. An I-131 request for a reentry permit, they want to do biometrics, mostly because they want to record those biometrics so they know who's coming and going from the country. But this thing was going to be really, like I said, onerous is really the only word. For example, petitioners were going to have to start giving biometric data. So Americans, for example, in the context of a K-1, would have had to do like fingerprints and maybe even eye scans to get their fiance into the United States. And then presumably the same thing associated with adjustment of status. And what we were seeing was this was going to be associated with the I-864 form, which is the affidavit of support. They might have even required it, looked like they were going to require it for like joint sponsors. So oftentimes we'll see folks, especially some of our younger couples, where you'll see they don't really have the ability to sponsor the applicant, but mom or dad may step in and act as a joint sponsor, especially during perhaps the adjustment phase of the process. And this was especially the case in the rules that were being brought online by the old administration, where they had this much higher financial obligation requirement, to have then required folks to do like retinal scans associated with dealing with an I-864 with an affidavit of support. I mean, that just to me seemed pretty over the top, and apparently it seemed over the top to this administration because they're rescinding the rule. So it looks like, at least for now, we have a reprieve from this, and hopefully this will continue to be the policy moving forward. But yeah, notwithstanding, I do understand there are security concerns and things out there regarding folks going in the United States, but this was really over the top. Like I said, petitioners, especially American citizens, I suspect it would have been challenged in the courts, but you know, it would have taken a while to go through all of that, and it would have had, in my opinion, rather negative impact on those who are simply trying to unite with their families in the United States.